rise. Court of Appeals, Division 1, is now in session.
Thank you very much. Please be seated. This is the time set for oral argument in State versus Murrieta. Let me go our cause number 1CA CR140280. Let's begin with introduction of counsel.
Michael Steinfeld on behalf of Mr. Murrieta.
Okay.
Andrew Riley on behalf of the state.
Very nice. Thank you. Welcome both. Let me go through a few preliminaries. Let me advise counsel that the panel has carefully reviewed the briefs. We have reviewed the pertinent portions of the record. We are familiar with your argument and the issues that you have raised, so you might wish to take that into account in your remarks. Each side has 20 minutes. If you, on behalf of the appellant, would like to reserve time for rebuttal, when you begin your remarks, if you would let us know if you'd like to do that, we'll do our best not to poach on your time, so you actually will end up with some rebuttal. We are recording the proceedings today, so when you begin speaking, if you would please restate your name. That way, if someone wants to listen or view the tape, they'll be able to identify who's speaking. So with that, we'll go ahead and begin.
Good morning. May it please the court. My name is Michael Steinfeld, and I represent Mr. Murrieta. I would like to try to reserve approximately 2 minutes for rebuttal if possible. When the trial court made its ruling regarding the preclusion of proposed cross-examination, it relied heavily upon Rule 404. But unfortunately, Rule 404 had no application in this case.
How was the trial judge to know that, given the generality of the objection?
Because the objection was raised by the state, and what was proffered by the defense was the content of what it wanted to go into. But beyond that, the defense also linked it to motive issues. By linking it to motive issues, that should have at least signaled the court that there was issues related to the constitutionality.
It's one thing to send a signal. What concerns me, and I know you're going to get to this, is whether this issue that you want to discuss is really before us. The only statement made by defense counsel, well, actually the judge is the one that raised the rule of evidence 404, and defense counsel then says, well, it's motive. Thus, everyone seemed to think what was in play was 404B. There wasn't any argument at all that 404B was not in play, and instead this should be analyzed under 401 to 403. So why is this properly preserved to begin with?
I actually disagree with the court as to the reference of motive going to the 404B analysis. I think the trial court was thinking 404B.
Well, let's go back then to my sub-question, which is, I didn't see any reference to, Judge, this should be analyzed under 401 and 403, or 2403.
I agree that it wasn't phrased specifically, Judge, this needs to be analyzed under 401 to 403. But by referencing motive bias, I think the inference, or at least the argument, was this needs to be analyzed under the Sixth Amendment, the right to confrontation.
You know, our trial judges have a tough time, and they really do need some help by counsel for both the state and defense. And I'm really struggling to see how this issue is preserved. You've given me your best shot. Do you have anything else on it?
I think the concern that I have with it is that if it's not preserved in this case, it will never be preserved, unfortunately. And the reason for that is that the proposed preservation that needs to occur is a proffer of what testimony would be given, along with a conjoined argument that this needs to be analyzed a certain way. But the primary analysis has to be a Sixth Amendment analysis. It has to be whether or not this comports with the right to confrontation and to cross-examine a witness.
Well, couldn't that be made through a motion in limine? Because in this case, you have a father who knows about his daughter and knows about these events, and as the victim, he can't, the defense can't do an interview, but he still knows about them. And so you say, Judge, we want to be able to cross-examine the victim about these events because it raises Crawford and Sixth Amendment and anything else you want to raise, and then the court gets to address those issues.
I don't think that's absolutely necessary. And I think that by Referring to 404, what the trial court really did was impose that burden where one doesn't exist. For example, in 404C, you have an absolute burden on the state that if it's a sexual issue and prior sexual conduct, the state has to provide notice. In 15.1, you have that if the state wants to introduce prior incidences under 404B, the state has to provide notice. 15.2 has no analogous provision, and 404 has no analogous provision for the defense. Could the defense have done that? Absolutely. I think the defense could have done that. And I typically advise attorneys in my office that they should try to litigate things ahead of time. But I don't think that's necessary by any means. I think that this is an issue that was brought up at the time that the state wanted to get into it. I think that's where there's an interesting counterpoint. Because one of the things that was raised during the argument was that the state had not also brought a motion in limine. So typically, when we talk about motions in limine, at least when I see them, the motion in limine is filed to try to prevent something from coming in, rather than to try to gain permission to bring something
Well,
in.
maybe your experience is different from mine, but I see lots of motions in limine designed to allow for the admission of evidence. Admittedly, the Latin term suggests exclusion, but the real point is that there should have been a notice to the court as to this evidence. And the court was quite clear in the dialogue, and I quote, "That's the kind of thing that should be brought up with a motion in limine a long time ago."
I agree that that's what the court said, but when the defense then responded that they hadn't filed any motions, the state hadn't filed any motions.
So what? So what?
I think
What?
the court's next response, I think, is most instructive as to where the court was coming from, which was, no, it's your motion. The minute you intend to use it, it's clear 404. By framing it as a 404 and imposing that requirement upon the defense when it's a clear 404, the trial court's entire basis for its background for that decision was premised upon the idea that there's some sort of notice requirement incumbent within 404 when defendants are proffering evidence.
You know, forgive me, I really don't read it that way, but I'll assume for the purpose that there should have been some information. But the problem here, and I get back to my original point. Defense counsel responds to that statement. Again, I will make a record, but I think it goes to her motive and bias to lie. There's no discussion of, judge, you need to analyze this under 401 and 403. There's just no discussion whatsoever. So I'm still kind of at the beginning, first base, so to speak, of why is this issue properly before us?
I think the best answer is because it's a town of Marana issue, that from the perspective of town of Marana, it only has to be minimally raised. It doesn't have to have a full discussion, and courts are presumed to know and apply the law correctly. And so when the defense attorney responds that this is a motive bias issue, that's an invocation of the standard language under Davis v. Alaska that we associate with confrontation issues.
You know, it actually reminds me of 404B, is what it reminds me of.
I was going to say it reminds me of 403.
Well, there's that too. Right.
That's what immediately pops to mind.
And Judge Portley, if it reminds you of 403, then again it's an appropriate invocation of 401 to 403. I think the only concern is if it invokes Rule 404. But the problem that I have with the notion of it invoking 404 is the inclusion of the "and bias" section. Because bias is listed nowhere in 404B. It's only motive that's listed in 404B.
Well, but 404B talks about including. It's not restrictive to just those 6 or 7 uses.
I agree that it's not restricted those 6 or 7 uses, but if we're going to talk about the notion of it being an invocation of something, then if we take the phrase motive and bias, it's typically associated with the Sixth Amendment assertion under Davis v. Alaska that defendants have the authority and the ability and the right to cross-examine on a witness's potential motive and bias.
Well, let's assume you persuaded us that this is just enough preserved to get there.
However unconvincing your assumption may be.
No, okay, you persuaded us. Okay. There's no question that on this record, the jury was presented with enormous amounts of evidence that the victim wanted to leave the home, wanted to get out of the home, was attempting to escape, leaving. The detectives testified, she testified. There's no question about it. So why is the evidence that she cut off her ankle bracelets at all more than just cumulative? Where's the bottom line here? Why isn't this harmless?
I think there are two different answers, and the first goes to the difference between cumulative and corroborative evidence. And the second, regarding harmlessness, I think goes to the weight in the credibility assessment between the two parties, if you will. Or not parties, I think it's unfair to characterize it as parties, but between the victim and the defendant. From a cumulative versus corroborative perspective, I've been struggling with what that really means between cumulative and corroborative. And the conclusion that I've come to from the cases is that evidence is cumulative if a fact has already been presented. And so when you look at cases such as Lopez and Dickens, what you have is certain facts that had already gotten in. You have things like certain testimony about a report had already gotten in. And so any additional testimony or any additional admission of that evidence and that fact is cumulative. Corroborative evidence, on the other hand, is additional facts that may bolster a conclusion that one wants someone to draw from those facts. And so I think the corroborative versus cumulative issue here is there was no testimony and no evidence that she had ever removed her ankle monitor that was ever presented to the jury.
Why is that at all significant? What's significant based on the argument that you raised, at least on appeal, is that it explained why she wanted to leave, that she may well have been fabricating or falsely accusing the defendant here. That information that she was doing everything possible to escape from the home or leave the home, that's the relevant fact. How she went about doing it, whether she cut off her ankle bracelet or perhaps did something else, maybe hijacked a car. I know that's not on the record, but as an example, that's the mechanism and how she did it. But the fact, the important fact, the material fact, is she wanted out.
I actually disagree with the court's characterization of it being a mechanism for proving a certain fact. The way that I interpret it under the corroborative versus cumulative is that the fact is that she tried to remove the ankle monitor. And to me, that proves the extent to which she was willing to go to in order to try to escape the house, to try to change her living circumstances. And that's what needed corroboration, is the assertion that she wanted to change her living circumstances.
But was that ever there was no debate about that. There was no controversy. She wanted out. So you could, forgive me, but there was just no facts to the contrary. So why did we need to know she cut off her ankle bracelet?
Because I think it goes to the scope of credibility and the scope of motive to possibly lie. And I think that that's the important thing, and that gets to the harmlessness analysis. Ultimately, what the jury had to do is take the testimony of the alleged victim in this case and weigh it against the confession and the attacked confession in this case. Now, what's notable in this case is that they actually acquitted him of some conduct. Mr. Murrieta was acquitted of the conduct that he rejected having occurred in the confession, the alleged confession. Now, what's notable about that is that by rejecting that accusation, the jury found that there was some credibility problem with the alleged victim, but they bolstered her credibility with his confession. If there was a better attack, a stronger attack against her credibility, that modifies that credibility assessment. Would it have absolutely led to a different result? I don't think that we can say that. But the problem is that it certainly does modify that credibility assessment, because what it does is it provides even more reason to disbelieve the accusation. You couple that with the modifications and changes in what her assertions were, the fact that with Samantha Tina Harrow, she initially said that she was molested up until the age of 9, but then when interviewed by a detective, suddenly that changed to 10 and 11. So we have age discrepancies between the accounts and the reports. The initial report didn't include anything with the looking to see if you're a virgin testimony. That only came after the defendant's alleged confession in this case. So at a minimum, I think a jury could have sat there and said to themselves, I see a change in her testimony. I see the extent to which she's willing to try to get out of this household, to try to mold this accusation to get out of this household, and could have then disbelieved at that point the accusation related to the checking to see if she's a virgin incident. So it's really that credibility assessment between the alleged perpetrator and the alleged victim in this case. And that credibility assessment, because he wasn't able to get into information that went to her credibility, that went to her motive to fabricate, I don't think that he was in a position where he could effectively argue to the jury then that she needed to be disbelieved, at least insofar as it related to the modification about the check to see if she's a virgin. He was really handicapped at that point, and he was unable at that point to present all the information that he wanted to. And I think that's where we get back to the fundamental importance of Machado and Gibson and Pryon. The focus in those cases was that defendants need to be empowered to cross-examine and present evidence on issues that prove some tendency of reasonable doubt. It's not that they have to prove incriminating evidence against somebody else. They have to show anything that might tend to exonerate them. And that's why credibility evidence is so important.
Well, they would only have to present enough to create a reasonable doubt.
I agree.
They don't have to present anything to exonerate.
I agree. I misspoke, and that wasn't my intent. It was a tendency towards exoneration, so creation of a reasonable doubt. I apologize for misspeaking, but you are right. They just have to present something that might create something of a reasonable doubt. And credibility information is that sort of information that's vitally important in that assessment. And I think that's why cases like Trotter have noted a party against whom a witness is produced has a right to show everything which may in the slightest degree affect his credibility. Well, this is information that would have bolstered his claim that this alleged victim had a motivation to lie and thus a lack of credibility. But he wasn't able to present it, even though it would have, at least in the slightest, affected the credibility of this alleged victim. So I think from a harmlessness perspective, because there's that credibility assessment, because there's that weighing issue, and because the jury has already demonstrated at least some skepticism about what this alleged victim has said and accounted, there's reason to believe that if we were to modify the credibility assessment even further, there very well could be a change, at least in some, of the allegations and convictions. With that, I see that I have 4:35. If the court has any other questions, I'd actually like to reserve the remainder of time. Thank you.
Okay, thank you.
Shorter. May it please the court, my name is Andrew Riley, Assistant Attorney General for the State of Arizona, appearing on behalf of the appellee in this matter. To begin, I'd like to start with the argument that the jury's verdict was somehow a referendum on the victim's testimony in this case. Appellant also denied in the first instance of there were three separate instances in this case that were discussed. In the first instance, appellant denied the digital penetration during that instance, and he was convicted of that. So there are more than just the actual intercourse convictions where he was convicted of, and that where he denied and he was convicted of. Secondly, the testimony from the victim concerning as it being an incredibly embarrassing situation, an incredibly unfortunate situation, was much more qualified when she was discussing the actual intercourse that it might have, and it was there, and it may, a little bit, and things of that sort. There was much more qualifying language than the very clear and unequivocal language involving all the other acts. So to say that the jury's verdict was somehow, the jury's acquittal on those two counts was somehow a referendum on the victim's testimony is simply not so. Secondly, I'd like to jump to, in addition to failing to put the judge on notice in this case that it should be that he believed the admissibility of this evidence should be governed under 401, 403. the appellant in this case simply offers no indication of, provides no factual support or factual basis for the actual removal of this monitor. Not in the sense that the monitor was removed, but we don't know when, we don't know where, we don't know how or under what circumstances, and there's nothing to suggest that when the monitor was removed, it was somehow tying her to appellant or tying her to appellant's home. There's also testimony in the record that she was at a group home for a portion of this time. So if she removed the ankle monitor, for all we know, she was trying to get away from the group home, or we don't know if the ankle monitor was removed after she was in juvenile detention after the allegations were made. There's no indication of this. And in addition to being the father, and as most fathers would be aware of this kind of stuff, the entire juvenile record was disclosed to appellant at trial. So the judge reviewed it in camera, and then the entire juvenile record was disclosed. Despite that, we have no specifics from the juvenile record. So at best,
Let me back up. What part of the juvenile record was disclosed? Was it the social record, or was it just the court's record?
from the social and the juvenile
So they would
adjudication record.
So they would have had the probation officer's notes.
They would have had the probation officer's notes, presumably if
Social file they would be in.
They had both.
Trust me.
They had both. The only things that I believe weren't disclosed after the in-camera review, and I would double check on that, but I believe was the birth certificates and vaccination records. Outside of that, the entire juvenile record was disclosed after the in-camera review, and same with the CPS file. All the files. Apparently, it was hundreds and hundreds of pages. But that was all disclosed, and they had it, and yet none of it kind of made it into the record for us to really look at. So based on based on that, and the judge's quick dismissal of it, and while the judge did make the ruling under 404B, the record clearly demonstrates that the evidence was precluded for the marginal relevance and for the cumulative nature and the prejudicial aspect of it. That was the judge's entire focus throughout the discussion with counsel on whether or not to have it admitted. As far as Machado somehow, as far as the argument that Machado no longer applies to any evidence offered by a defendant, that's simply not what Machado holds, and in Tankersley, the Arizona Supreme Court is plainly...
Counsel, forgive me, let me ask you to scroll back to something you just said.
Sure.
Based on my review of the record, the removal of the ankle bracelet, it came up just once, and that, I think you both have cited in your briefing on appeal, the colloquy between the court and counsel about this. Did it come up anywhere else?
Not that I was able to.
So we're all on the same page. Okay. Based on my review of what the court and defense counsel were discussing, I don't see the court making any implicit determination that the evidence here was unfairly prejudicial. I just don't see any thought process about 401 or 403. Are you reading it differently? Am I missing something here? It appeared to me that the court looked at this as 404. Yes, he could have pursued it. Perhaps he could have been clearer if he had looked at, the weighing and the balancing and all that good stuff. But I didn't see that he did that. He just said, it's clear she's a runaway. I'm not going to let it in.
And I agree with that assessment. I guess my initial response, my guttural reaction to that is that it's a cumulative kind of nature. We're hearing that it's unnecessary to get to that point, and so I view that as an implicit 403 rule or 403 determination that we're going to hear this. There's no sense in getting into it, particularly after earlier in the discussion before that specific record was made. Clearly talked about sanitizing the juvenile adjudication, said, look, we're not getting into punishment. We're not getting into what the crime that she committed. We're not getting into any of that here. And I think it was just kind of a piggyback. It was a few pages later in the record after the opening argument of the state, but it was just kind of a piggyback on that initial thought. We've already gone over this, and we're not getting into it for these reasons. And then when the appellant said, but it shows that she's running away, the judge says, well, we're going to hear that, and that is an incredibly important point because the state doesn't contest that. The only issue is not how, I mean, she wanted to get away by God. She was trying her darndest to get away. And the only contention was why. What does that show? And the state said it showed that she was being sexually abused repeatedly, and that was her testimony. And appellant was free to argue that it showed that she was more likely to fabricate allegations, which is what he did. There was no restriction on his ability to make that argument or his ability to proffer that. It just there was no contention that she was trying to get away. We all agree on that fact, and so that's where, like I said, the judge made his cumulative the implicit cumulative finding and saying that it was unnecessary. And then going back to the Machado claim, as I said, Tankersley plainly says that 404B governs the admissibility of other acts of third parties. Machado narrowed that a little bit solely as it relates to third-party culpability evidence. In doing so, Machado cites Lucas, which was a Sixth Circuit case, which in turn relied on a Third Circuit case, saying that we find the Third Circuit's analysis to be persuasive under those circumstances. And the Third Circuit holds the same thing, essentially that the admissibility, what they call reverse 404B evidence, which is third-party culpability evidence, it's another term for it, but that reverse 404B evidence in the Third Circuit is governed by 401 through 403, as it is here, and Rule 404B applies regardless of by whom or against whom the evidence is being offered. It's just in the reverse 404B context, defendants are given a little bit more leeway in the admission.
Just in Lucas.
This was this is Lucas citing Stevens.
Right.
The third, there's a big analysis, and it's important also, the Lucas is the concurrence. So actually the Sixth Circuit says 404B applies across the board. This is just the concurrence from Lucas. But essentially it's just saying that defendants are given more leeway, and it makes sense when you step back and you think about it in the terms of identity. If offering a prior crime or another act, a bad act, let's say, I know it's not it's other acts, but a prior crime to show identity, the state's required to have this high hurdle. It's got to show that it's a signature crime. It's got to show by clear and convincing evidence that it occurred, and then the signature crime aspect. All third-party culpability evidence is basically identity, but offered by the defendant. And all it's saying is the defendant gets a little bit more leeway when proving identity. They don't need to clear these high hurdles, and that high hurdle to get to it by proving clear and convincing evidence and a signature crime. And Lucas, in the concurrence, discusses it thoroughly. I mean, there is a distinct policy difference between the high burden to prove identity and the fact that defendants shouldn't be held to such a high burden when trying to rebut identity through 404B evidence. And that's essentially the only difference. Like I said, the Third Circuit, the Seventh Circuit holds very similarly, but otherwise they both make perfectly clear, the Third Circuit in Williams after Stevens, which is a 2006 case, and the Seventh Circuit in Seals that says, look, 404B applies to acts by third parties. It's just this reverse 404B evidence is a different standard because it should come in a little bit more when the defendant is using it as a shield, as opposed to the state using it as a sword under those circumstances. And if there's no further questions, I guess I'll bow out.
Well, the going's good, okay?
Yeah, exactly, yeah. And on that, the state will rest on the arguments in its briefing and ask that you affirm the convictions and sentences of the trial court. Thank you very much.
I'd actually like to jump straight to the Machado analysis because the state's analysis misses the importance of Abuma Salam in that case. At the exact same point in paragraph 14 where the Supreme Court cites to the Lucas concurrence, they also cite to Abuma Salam. Abuma Salam held that 404B did not apply in a completely different type of case. It was not a misidentification case. It was not a third-party defense case. In that case, the defense urged that they had been duped. It was an intent case, if you will. They had been duped into couriering drugs, and what they wanted to present was evidence that the people who had duped them had duped somebody else before. And that evidence should have been allowed at least under a 404 analysis, according to Abu Musallam, because of the fact that 404 didn't apply. Now, they ended up affirming the ruling on separate 403 grounds in that case, but from a 404 perspective, even though it wasn't a misidentification case, they still ended up applying it. Now, also notably in that case, in Abu Musallam, they cited to McClure, which was a duress defense case. In that particular case, the defendant attempted to argue that while he had sold drugs to an undercover officer, he had only done it because the confidential informant had threatened him to do so, and he did it in response to that threat. Upon cross-examination, they asked whether or not the confidential informant had given those threats, and the confidential informant refused, said that he had not. So the defense wanted to present evidence of 3 different witnesses, 3 different victims of the confidential informant, if you will, who all would have testified that they also were threatened by that confidential informant and engaged in drug sales because of it. So 404, the restriction isn't just to third-party defense cases. And indeed, even if you look closer at Stevens isn't a pure third-party defense case. Stevens is a misidentification case because in Stevens, the defendant had been accused of 2 crimes, but initially there was a series of 3 crimes that the investigating agency thought were all connected. However, through an identification process, the individual had been cleared of that 3rd one because the victim did not identify Mr. Stevens. So Mr. Stevens wanted to present that for the purposes of showing that he was innocent, for the purposes of creating reasonable doubt. I think the functional difference here is that there's a difference between what the state is saying, and what the state's ultimately saying is that it's okay for defendants to get into the information if they can incriminate somebody else. But that's not the standard. The appropriate standard is that defendants can get into the information if it might tend to create a reasonable doubt. Third-party defenses are merely the conduit that we've had, but the language that we've used and the policies upon which we've relied have always focused on defendants being able to prove a reasonable doubt or establish a reasonable doubt, to try to prove their innocence in some sort of a way. I think that's why you see in Abu Musallam and McClure that it applies to a duress defense or it applies to a defense going to intent that they were merely duped. I think that's why in Stevens you have the scenario where it's applying to a misidentification. But if you read even further in the Lucas concurrence, you see that there's several scenarios where the state has tried to proffer it against third parties, and over a defense objection, it's been authorized. You have cases like Cresdorn, for example, where it was evidence of a third person's prior acceptance of a payoff. Well, it had nothing to do with the defendant. The defendant had not previously accepted a payoff. And so the court ended up ruling that because it didn't have anything to do with the defendant, and what it actually had to do with was more along the lines of co-conspirators, that these co-conspirators were making payoffs in the past, it didn't have anything to do with trying to convict a defendant based upon the defendant's propensity. You see the exact same thing in Arizona with Connor, where a prior burglary was presented, of which the defendant was suspected, but it was presented for a non-propensity purpose. It was presented to try to show the victim's state of mind. 404 does not apply when evidence is being presented in such a fashion that it does not try to obtain a conviction based upon propensity evidence. When a defendant tries to present evidence in an exonerating fashion, in a fashion trying to create reasonable doubt, it's not propensity evidence aimed towards conviction.
Well, I'd like to thank you both for your argument and your briefing. We don't have very many arguments in criminal cases, and we find them helpful, and I would note that for your future reference, because we really do find the arguments helpful. We will take this matter under advisement and issue a decision in due course. Thank you very much.